Can you hear me?
Hello, yes, we can.
Okay, great. It's been crashing for me for a while. Every time I log in, I hope it stays now.
Hi everyone, can you hear me? So just to introduce myself, this is Judge Khalid. I think Judge Hiba should join us as well. And Judge Rohit, he should have joined us, but I don't know what the obstacles that he is facing, to be honest. So I just want to make sure that everyone is here. The claimant is here and respondent is here as well. Okay, great. Judge Hiba, can you hear us?
Hello, can you hear me?
Yes, I can hear you.
Yes, great. So yeah, some
Hi,
audio
am
and
I
video
audible as
issues.
well?
Oh, great.
Oh, great. You made it. That's perfect.
I just wanted to inquire if anyone from the COS Moot team is in this room.
What kind of inquiries?
Well, I have a hard stop in
Yeah,
the next 37 minutes now, and I hardly think a 90-minute round can be concluded in 37 minutes.
correct. I
So I would like to
understand.
know the
Same
way ahead.
here. Okay, so I think the best thing that we can do right now is just to start. I think so.
I don't think so, because I will need to drop out unless the COS team is happy to continue the round without me. I don't think it's productive to start and then have me drop off midway. I don't think that's fair to the teams. I don't think it's fair to the other judges.
I think so. Let me just mention them in the chat.
If you've seen my emails, I think I've been saying that for a while now. The team has not been responsive.
I see. I've experienced the same. I think same also to Judge Heba. So all of us, we were trying to
Yes.
join.
I know some of the other judges personally in the other rounds, they faced the same issue. So it's not just our room.
Um, 2:30. Ophelia, yeah, I just saw your message. What's 2:30 is for your time zone? Is it after 1 hour or?
It is the same with your time zone.
Oh, okay. So
Yes.
it's after 90 minutes from now.
Yes, yes.
Yeah, actually, just
Yes.
to also, I'm having trouble to open my video, so it's not even open. It's not a big deal. We can proceed without it, but just one more issue on the top.
Okay, we can proceed. I think so, to be honest. But let's handle this and save our time. I think that the IFC admin, I don't know whoever is that, he did not respond, and he's not going to respond shortly. So the best thing is to proceed. What do you think, Judge Hiba?
I'm okay either way. I mean, rescheduling or proceeding, I think it depends on. I can stay for longer if we need to. I think I can make up for the missing time if that would help. But I'm not sure about the rules for the moot as well. Maybe it has to be 3 judges and Rohit can't be with us. Then in this case, they need to help us here.
Hi, this is Vishwam from Webnyay. Are we missing judges or are we missing team members?
Vishwam, nobody is missing. As I've communicated to your team as well as the COS Moot team, I am unavailable after the next now 33 minutes because of prior commitments that I had scheduled, because this round was supposed to start 57 minutes ago, right? So I am not available after a certain point of time, and the round cannot be completed in such a short span of time. That's the challenge. I'm happy to leave it to the other two judges to take it, but that's precisely why I wanted clarification from the Moot team and the organizers.
Understood, Rohit. I apologize for the inconvenience we had. I think we can start the round and then you can leave whenever you have to, and the other two judges can then sort of take over. And I can say this because there are other rounds as well, and the DIFC courts have asked us to sort of start the round there as well.
We also want to ask if there's any chance to reschedule this to just to give the chances, the proper chances for both
Yes.
parties.
I think Marjorie is here as well. Hi, Marjorie. Marjorie, can you? I think you're on mute, Marjorie.
Hello.
Hi, Marjorie. I think Rohit, who's one of the judges, will have to leave soon, but I think we can still start the round, right? I think he's only around for like half an hour, but
Yes.
we've got everybody else.
Yes, we can. Yes, please.
Okay.
But there is another thing is that in terms of time.
So both.
Yeah. So in terms of time.
Sorry, Heba, please continue.
Oh no, it's just that the allocated time for the submissions. Do we have to extend the session, or how would that work now? I'm happy to stay for longer if it needs to be, but I just need clarity in terms of so that everyone knows what to expect. Okay, couldn't hear me. Can you hear me now? Can you hear me now?
I can hear you, Eva.
Yes, Eva, we can hear you.
Okay, Marjorie seems to not hear me. So, Marjorie, can you confirm if you can hear me now? You're on mute. Okay, why don't we start and let's kick off and then see how it goes?
Okay, so I will just say one last thing, perhaps from my perspective. Since I have half an hour left, I won't be able to go through even one-side submissions. So I don't know whether it makes sense for me to just drop off now, since I won't be able to score them anyway.
Up to you. You're in the round. You're in the next round tomorrow, right?
I'm in the round tomorrow. Yes.
Okay. I mean, I think it's up to you, but maybe it's useful as well for tomorrow if you would like to stay, if you can make it.
Well, I mean, they're independent rounds. I don't see the benefit of spending the next half an hour on tomorrow's round. So if there's anything else, I could be emailed, or my phone numbers are available as well. Happy to speak, but I think I will drop off for the time being.
Okay.
Since I'm not marking anyone anyway.
I think we can ask them for. I think the session is recorded, so perhaps we can have a chance to see that recording at your own time later on. So
Sure.
catch up.
Sure, if that's something that the organizers want me to do, then I can be informed.
All right. Thank you, Rohit. Thank you so much.
All right. Well, best of luck to the teams and best of luck to the two of you.
Thank you. Tim, you can proceed and don't worry about the time. Use your time. If we have to run over, we'll see that. If we have to reschedule, we'll see it. But just so to be fair to you as well, proceed with your initial plan. You don't need to adjust anything.
We just wanted to state that if there will be some extensions, we have another pleading as well at 2:30, like in 90 minutes. That's why.
Okay.
I think maybe we can start. I think we're probably wasting a lot of time in this admin stuff. So I would suggest we start and then the judges can decide around the extensions.
Okay.
So please, the claimant, you can start. Is there any representatives for the claimant? Nigeria University.
So, Ophelia, you're for the defendant?
Yes, they are.
Okay.
Okay, good day, sir. We are currently having some issues connecting the mic of the senior claimant. So just give us a moment and we'll proceed with that.
Okay. What's your estimate? Oh, he left. Okay, great.
I thought for a moment that the technical difficulties are only for the judges. Apparently, it's not.
Um, hello. Hello. Can anyone hear me?
Can you hear me?
Can you hear me? Hello.
Yes.
All right, perfect.
So
Have the round started for this round? Haven't.
yeah, I'm really sorry for the delays. I was having a lot of issues with my camera and audio, so I was struggling to fix it. I just figured out how to do it a few minutes ago. I'm really sorry for the delay.
Only you. Everyone has been having technical trouble. So, and we can.
Okay, thank you very much. So I'm the senior claimant counsel, and it was my junior counsel spoke the other time while I was trying to rectify the issue. So if it's okay with everyone, we could proceed.
So, Khalid, the claimant is
Hi.
here.
Okay, great. So we can start. So the claimant, if you please, can start your pleading and you can start your case. We're here.
Okay. Thank you once again, everyone, for having us. First of all, I am by name Chuku Michael, and appearing with me is Barnabas. I am the senior claimant counsel, and Barnabas is the junior claimant counsel. And for the purpose of clarity, we would like to inform the court on how we choose to allot our time, subject to any amendment that the court deems fit to make. So basically, each team is given 45 minutes, and we intend that during the claimant claim session, I would take 25 minutes, which is 15 minutes for my substantial argument and 10 minutes for my rebuttal. While my co-counsel Barnabas, who would be handling the counter response to the counterclaim from the defendant, would take 10 minutes for his substantial argument as well as 10 minutes for his sole rebuttal. That being said, if it's okay with the court, counsel wishes to proceed with his submission for. Can I proceed? Hello, can you hear me?
Yes, please go
Yes,
on.
yes, we do. Yes.
All right. Beautiful day to distinguished members of this court. I believe we all know why we are here. This is an action brought first by my client, the claimant, against Solar Dreams, the defendant, in tort and in contract. The facts of this case are quite clear, unambiguous, and straight to the point. My client had actually entered into a contractual agreement to have a one-time yogic experience outside space, which the defendant had promised to execute substantially without any form of alteration or frustration whatsoever. But sadly, the dreams of my client was cut short due to the negligence, and when I say negligence, I mean gross negligent conduct of the defendant in conducting certain protocols which it should be well aware and well conversant with conducting. And not just that, the defendant also went ahead to breach silent and fundamental terms in the contractual arrangement which my client had entered between them. It is based on these facts that my client had brought this action to this distinguished and competent court to determine claims of negligence against the defendant and breach of contract in that light. So based on these facts, your lordships, the claimant has succinctly raised two substantive issues for determination, which is first, whether the defendant is liable in tort to the claimant, and secondly, whether the defendant is liable in breach of contract to the defendant. Now, proceeding with the first issue, it's our submission that the defendant is liable to my client in the sort of negligence because the defendant had conducted the procedure for engagement in the said audit experience negligently and without the reasonable care that was expected of a reasonable expert in the field of the defendant. Now, in order to explain and succinctly make this claim before this court, it's important that counsel informs about the doctrine of tortious negligence. The Lordship, tortious negligence is not foreign to this court, I believe, and even to a layman. It's simple as a burden placed on a person so that when conducting itself with regards activities which related to another person, he or she is expected to do so with the reasonable standard of care that is expected, not of an expert in the field, not of the best man or woman in that particular field, but of a reasonable person. This principle was enunciated in the common law case of Donegal and Stevenson, where the court reiterated that just as a neighbor owes the duty of care to his co-neighbor, so does any person, whether or not in contractual relationship, so long as a proxy relationship exists between them, is expected to handle his conduct with relation to another with a reasonable standard of care. This is simply the doctrine of negligence. And based on this, the court has reiterated that in order to substantially prove claims of negligence, that three elements must be established. First, that a duty of care exists between the parties. Secondly, that duty of care was in fact breached. And thirdly, that based on this breach, consequential damages have arisen. This is in fact reflected in Article 17 of the DIFC laws of obligations, which clearly enunciated and reflected this element which must be established. Now, it is our submission based on this issue that these three elements are present and are duly established, and I will go further to evidence this. First, the question of whether or not the defendant owed my client a duty of care. Your Lordship, this is undisputed because in fact, the fact that there is in fact a contractual relationship between these two parties, wherein the defendant is the offeror, having and required to execute some certain functions which my client has in fact furnished consideration for, shows that there is in fact a duty of care which must be executed. This is clearly reflected in, as we know it, Article 18 of the said law which I have made reference to. Now, the question now begs whether the duty of care was in fact breached. Your Lordship, duty of care, to prove that there is in fact a breach of duty of care, it must be showed that the defendant had in fact conducted its activities, its performance, its conduct in such a way that will be deemed to be careless, as expected of a person who knows and understands his duties in the defendant's position. And the question is, was the defendant in fact careless in his conduct? The answer to this question is succinctly yes. And
I think we lost him.
Yeah, I lost the audio as well.
If there's anyone of the claimants team, we cannot turn it to the respondent yet, or the defendant. He needs to complete his pleading.
Okay, Mr. Khalid, I didn't get your submission correctly.
hear me? I'm really sorry for the glitch. Can you hear me?
Yes.
Okay, great. Yes,
Hello?
we can hear you.
Okay. I will proceed then. So I was making reference to the second element, which is on breach of duty of care, which is clearly evident in the facts of this case, where the defendant had conducted itself negligently, which has exposed my client to first, the variant of COVID-19, secondly, economic and financial loss, thirdly, reputational damage, which in all entirety resulted from their lack of due diligence in ensuring that the safety protocols were validly and succinctly conducted during the preparations for the launch. And this is clearly evident because as the fact yes, Your Lordship.
Yeah, sorry. We just because we lost you on the breach of duty aspect. I think we didn't hear it all. So if you can just go back to this point.
Okay,
The
no
breach of
problem.
duty, yes, yes. You were just breaking up at that point.
Okay, I'm really sorry about that. So what I was trying to say in summary about breach of duty is that having established that the duty of care exists, it is important that Article 21 of the laws of obligations clearly provides that breach of duty can be established when it is shown that the defendant has conducted itself in a careless manner towards the preservation or maintenance of the duty or standard placed on him or her or the organization per se. Now, it is now important to prove and show that the conduct of the defendant was in fact careless and unreasonable as expected of them. And counsel is now making a reference to the undisputed facts of this case, which clearly evidence a nonsensical attitude, if I would place it, on the part of the defendant towards the preservation of the protection of my client's interest with regards ensuring that the yogic experience was completed. Secondly, towards the health preservation and maintenance of my client to ensure that my client is not exposed to an unexpected health risk. And thirdly, towards reputational damage, which is in fact cost my client. Now, it is important to evidence a good example or a typical example of this negligent conduct or this breach was reflected in the instance where the defendant had conducted a PCR test on my client and had the leverage of waiting patiently for the PCR test to come before proceeding with the launch. Your Lordship, the defendant hurriedly conducted this launch without waiting, regardless of the delay. It is important to note that the defendant was in no way in any rush, because as reflected, I would like to direct the mind of this court to the space flight agreement between both parties. When you see in Article 1 of the space flight agreement, you would find out that the defendant had between 15th of February 2024 to 23rd of February 2024 to conduct the launch. That is, in the light of any delay, they had the authority, the power to shift, adjourn, postpone the launch to avoid any unforeseen risk. However, the defendant hurriedly conducted this launch, resulting in the exposure of my client to variants of COVID-19 and reputational and economic loss, which I have already announced. Therefore, it's a submission on this element that the defendant's negligent conduct had in fact caused the defendant had in fact breached the duty of care placed on him by law to protect the interest, the health, the financial, and the reputational interest of my clients with regards to the transaction between them. I'm moving to the third element, which is whether consequential damages have arisen from the transaction between these parties. Clearly, Your Lordship, from what I have already announced and explained or examined, it is clear that my client has suffered various kinds of risk damages, which has resulted from the breach of duty by the defendant. As I have already outlined to this honorable court, my client suffered reputational damage because my client, as we all know, as reflected in the fact, my client is a professional YouTuber with over 27.3 million followers. And my client had went on to make assertions promising her enthusiastic followers of a one-time shoot in outer space, performing her well-known yoga routine. However, this activity never occurred. Not just that, My client had, in fact, as reflected in the space flight agreement, particularly, I think, Article 3, and also the uncontested part, my client had paid $7.5 million US, $7.5 million US to the defendant. And till this very day, the defendant had not talked about rescheduling, the defendant had not spoken about refunds, nothing, which has also resulted in economic loss on the part of my client and what have you. Therefore, it's our submission on this issue, Your Lordship, that the defendant had in fact committed a grievous sort of negligence against my client, and this court should resolve this issue in our favor and declare that the defendant is in fact liable in the tort of negligence against my client. Now, moving hurriedly to the second issue, which is whether the defendant is liable for breach of contract against my client. It's important to note that
Mr. Michael, if you please, I don't want to just to let a chance for the defendant. If you can just make it in brief, thank you.
Okay, no problems. I will just succinctly, I'll make this submission in a very summarized manner. First, breach of contract simply means that there are agreements between two parties, and a party unilaterally goes against these terms. This term, the breach of contract should arise from non-performance, ineffective performance, and the various means of a violation or wrongful performance thereabout. This is clearly reflected in Article 77 of the Contract Law of 2004. However, in this case before the Honorable Court, our submission that the defendant had breached the clear, outright terms of the space flight agreement between my client and themselves by non-performance, and also outright contravention with terms of the agreement. First, by non-performance, as we all know, as reflected in the uncontested fact, my client expected that at the end of the launch, at the end of the space trip, all her expectations and hopes would have been met. She would have had her week experience. She would have made her Vogue videos. She would have had increased income as expected. She would have had increased followers as expected, and a lot of other expectations which she made clear, softened to the defendant before entering the contract. However, none, and I repeat, Your Lordships, none of these expectations were met. None. It is also important to note that the defendant had also incorporated in their contract, that is in the space flight agreement, that upon cancellation of the flight between, as arranged between both parties, that there is expected to be refund, especially when such cancellation is coming from the defendants themselves. You will find it in Article 3, Article 3 of the space flight agreement, where it is clearly incorporated that when the defendant is the one making the cancellation, then refunds are expected. However, till this very moment, no refunds have been seen. Nothing at all to that effect. Rather, the defendant chooses to make counterclaims against my client, claiming for damages which had resulted from their negligent conduct. So based on this summarized fact, it's our submission, distinguished members of this court and honorable judges, that the defendant should be held liable in tort against my client and liable in breach of contract against my client. And this court should award the sum of $15 million as special and general damages for both the tort of negligence and the contractual breach. May it please the Honorable Court. I raise my case. Thank you.
Thanks, the claimant. Thanks, Mr. Michael. And I have no questions. Judge Heva, do you have any questions to the claimant before we can go on here, the defendant?
Yeah, just one question in relation to the damages. So I'm just trying to, I'm not sure I got that because of the breakup. So it's pure economic losses?
Your Lordship, I said, can you hear me? Hello?
Yes. No, I'm just asking about in terms of articulating the damages. Is it pure economic losses?
Yeah, it's not just economic and reputational loss.
Okay, thank you.
Economic and reputational damage, which amounts to economic and reputational loss.
Thank you.
I just have a question, and if you can please, if you can just want an answer in brief. What's your input regarding the omission of declaration?
My input regarding what?
Regarding your what's your input regarding the omission of declaration?
The medical declaration.
Yes.
Okay, thank you, Your Lordship, for the question. Clearly, my client is not a medical expert, first off. And the undisputed fact clearly stated that my client experienced headache 5 years ago, not today, not before 2020, 5 years ago. And a clear calculation of 5 years ago would mean 2019, even before COVID-19 virus existed. And my client had consistently performed yoga from 2019 to this very date. The headache had never, and I repeat, never interrupted the performance, the expertise performance of my client's business enterprise. Therefore, the medical declaration was brought to my client to attest to her medical fitness to participate in the travel. Specifically, to participate in the travel, I would have loved to read out the specific paragraph, which made, I think it's paragraph 8, which told her to testify to the best of her knowledge that she was aware of any medical symptoms or that may affect her fitness. Emphasis on that may affect her fitness to participate in the space flight. From what I have stated, the headaches were in no way, to the best of her knowledge, capable of affecting her fitness to participate in the space flight. Therefore, my client was not and cannot be bound by the non-disclosure on with the regards the medical declaration. Thank you,
Thank you.
for that question.
Thank you so much. Thank you so much. Let's go and we have here Miss Ophelia. She is representing the defendant. You can proceed.
Thank you very much. Good afternoon, honorable judges and respectable audience. My name is Ophelia Ahmadzada, and I am a senior counsel representing defendant Solar Dream Inc., along with my co-counsel, Ms. Humar Qasimzada, junior counsel. We are representing Solar Dream Inc. against Ms. Artemis Astrotea, and we shall address the two grounds for the claim and counterclaim respectively. I will begin with the first ground regarding the defense of the defendant, that we deny any liability to the claimant since the defendant has acted in its best efforts to comply with safety measures and there is no liability of the defendant under the tort as well. And my co-counsel shall address the second ground regarding the counterclaim of the defendant, that the claimant's breach of contract resulted in the loss of reputation for the defendant. We shall be pleased to the court to allocate 70 minutes as a speech time and 5 minutes each for rebuttal. Your Honors, at the heart of this case lies the fundamental issue of fairness, where the failure of the claimant to disclose crucial medical conditions directly resulted in the breach of her contractual obligations. And it's imperative to recognize that upholding contractual agreements is paramount, and the defendant should not be held liable for any economic repercussions that stemmed from the claimant's lack of disclosure. The case at hand is amongst Solar Dream Inc. and Ms. Artemis Astrotea regarding the spaceflight retreat, which was offered by the Solar Dream, and the passengers of it were taken to a bespoke space station operated by a celestial habitat called Space Yoga Mat. And the participants will have to be offered a week-long series of the guided sessions with yoga classes, and the whole experience would have costed a 10 million. However, besides that, Miss Artemis Astrotea decided to purchase this ticket because she decided that her chronic headaches would have been healed by participating in this retreat. And for that, the parties have entered into the space flight agreement, which required certain medical evaluations before boarding on the flight. Despite the fact that the claimant was offered both medical declaration and medical history log, and she was asked to fill out all ailments that she suffers from and any medical conditions or symptoms that may affect her participation, she never made any mention of her chronic headaches. The reason for that she was afraid that she won't be allowed by the defendant to participate in the retreat. And even though, due to the outbreak of the COVID variant, the mandatory flow test and PCR test were required, the defendant has not waited for the PCR test simply because there was a sufficient amount of the mandatory flow test for the parties to determine whether there is a virus, and also considering that the window for a launch was likely to close due to meteorological conditions, the defendant decided to proceed and therefore has not waited for it. With these facts in mind, the Council would like to begin its arguments on the first ground, firstly regarding the non-breach of the contract by the defendant, and for that we are making two submissions. Firstly, the claimant has not informed about her medical conditions, and secondly, the defendant has undertook its best efforts. However, some risks still may remain unavoidable. As for our second argument, we submit that there is no liability under the tort, and for that we submit that under the also non-liability exclusion clause of the agreement, the defendant has no liability under the tort and no liability under the tort of the applicable law. Proceeding with our first argument, that the claimant has not informed about her medical conditions such as constant chronic headaches, clauses 5.2, 5.3, and 5.5 of the spaceflight agreement signed between the parties actually shows us that the passengers declares and represents that to the best of their knowledge and belief that they are not aware of any medical conditions or symptoms of potential medical conditions that may affect their fitness to participate in the spaceflight. And they are also further acknowledge that the importance of providing accurate and complete information during medical evaluations. Also, based on the governing law, namely Article 78 of the DIFC Law number 6 of 2004, contract law, a party may not rely on non-performance of the other party if it caused by the first party's act. Since the claimant has never mentioned about her chronic headaches and those violated the provisions of the contract by the parties, the defendant cannot be held responsible or liable for any actions of the claimant. Also, the claimant deliberately didn't notify the defendant about severe medical conditions despite understanding the seriousness of her conditions. She was worried that the defendant will not allow to board on the flight, therefore she has hidden this information. We can also provide the decision of Harlow versus Haiti of the DIFC Court of the Small Claims Tribunal, where it was also established that the first party cannot allege the non-performance from the other party when it failed to perform its own obligations and responsibilities. And the decision of that case also aligns with the statutory language of the Article 78 of the DIFC Law number 6 of 2004, basically contract law. And the key test here is that non-performance of the contract was clearly caused by the actions of the first party. In that case, it's also stated that the court found that delay would have ended if the defendant would have provided the corrected signature. So here, the actions also dependent on the other party, and therefore the liability cannot be held on the other party if there is a non-performance from the other side. To conclude our first arguments, we state that the defendant should not be held liable for the actions of the claimant based both on the governing law and the case law. Proceeding with our second argument, Your Honors, the defendant undertook its best efforts to comply with safety requirements. As also stated in the agreement, namely in the clause 4.1 of the spaceflight agreement between the parties, The passenger acknowledges and accepts that space travel involves inherent risks, uncertainties, and the possibility of unforeseen events. And the passenger is aware that despite the spaceflight's operator's best efforts, certain risks may remain unavoidable. As we can clearly see that the passenger should understand that certain risks may still remain unavoidable, and the importance here is that defendant holds the obligation of performing to its best efforts. As also stated in Article 59.2 of the DIFC Law number 6 of 2004 of the Contract Law, if an obligation of the party constitutes a duty of the best efforts, the party should make efforts as a reasonable person of the same kind in a similar circumstances would make. So for that, we need to understand what the reasonable person test is. And for that, we refer to the decisions from the leading common law courts around the world, which are regularly cited in the DIFC as the persuasive authority. For that, we present a case decided by the Supreme Court of Wisconsin, Osborne versus Montgomery, where the reasonable person test has been established and is generally regarded as the level of care implemented under the same or similar circumstances by the great mass of mankind, often referred to as generally accepted standard. In our case, we can see that defendant has acted as a reasonable person of the same kind in the same circumstances would have made. And the defendant has undertaken a reasonable level of care that a normal person would do under the same circumstances. As soon as the positive results of the claimant has come out, the defendant has asked all of the passengers to wear masks and gloves for the duration of the flight. Also, the meditation and yoga sessions went ahead without the claimant, and the space yoga mat was actually sealed off the rest of the floating haven station, which shows that defendant has established all the reasonable actions to make sure that the claimant is isolated from the rest of the group, from the passengers and from the crew, so that they are not transmitting the virus. And it decided to land prematurely already on the fourth day when he saw that the risk for the passengers and for the whole crew has been increasing. Despite all of these efforts, obviously some of the risks remain unavoidable, also because the claimant has not disclosed her information about her medical situation, and therefore the defendant could not predict that it can lead and cause such kind of risk for the whole crew. Your Honors, in light of the effort that the defendant undertook, it has completed all of its best efforts that a reasonable person would do, and therefore he cannot be held liable for the breach of contract. With regard to our last submission, we submit that defendant is also not liable for damages alleged by the claimant under tort. First of all, we state that Article 32 of DIFC Law number 5 of 2005, Law of Obligations, it states that the liability of the defendant arises if he knows that he intentionally induced the breach of the obligation and as a result, the claimant has suffered the loss. But in our case, there is neither a duty of care under tort for defendant or any other legal obligations. We can also see from the other leading decisions of the common law countries, such as BPP solicitors and others versus Hodges Holland, their breach of duty was established as to be not only the fact that defendant should prove that it failed to comply with it, but also the duty was owed to him, and it was the duty which resulted in the loss as a result for the claimant. We can clearly see that defendant cannot be held liable for any loss of earnings that the claimant has incurred as a YouTuber due to her inability to film a series of yoga sessions, since defendant, first of all, has not been informed that she is such a widely a YouTuber with a huge YouTube channel. And we cannot state that this duty was owed to defendant, and it was the duty of the defendant in respect of which this loss has been suffered. Also, we cannot state that there is any liability for the defendant because he did not intentionally induce the breach of that obligation, and as a result of which claimant suffered the loss. And reasonably, the defendant cannot foresee the fact that there can be certain losses incurred for the claimant as a YouTuber because of her inability to earn some earnings or to earn something from her advertisements. And lastly, also, we want to state that in the article 4.5 of the agreement between the parties, although the claimant states that the damages are in the amount of 5 million, we can clearly see that the spaceflight operator's total liability for any and all claims shall be limited to maximum of 1 million. So even if the defendant is held liable, the amount of damages cannot exceed 1 million. Therefore, the claimant cannot demand 5 million in any case. Hence, in the light of time, I shall conclude my submissions by stating that the defendant is not liable for any breach of contract or for tort. Firstly, it has made all its best efforts to comply with safety protocols, but since he has not been informed about the medical conditions of the claimant, he cannot be held liable for her actions. Also, the defendant is not liable under tort since there is no duty of care or any legal obligation in regard to that. Your Honors, we respectfully request the following relief from this honorable tribunal to declare that the defendant is not liable for any damages to the claimant. Thank you.
Thanks, Ms. Ophelia. Thanks so much. Judge Heba, do you have any questions? I have just one question, but after you, if you have any.
Oh, please go ahead.
Okay, great. So, Ms. Ophelia, representing the defendant, do you think that your client has taken all the required security measures by taking off the flight before receiving the PCR results or not?
We believe that he has undertaken all of the necessary measures. He has done at least some isolation measures in order to prevent the transmission of the virus during the flight. However, we note that it's important to note that if the defendant would have known that there are chronic headaches of the claimant, he wouldn't have gone to the flight in the first place, and he would have made sure that the PCR tests have come, and after that only lodged the flight. But as a result of the lack of this information, it was harder for the defendant to act in this case.
Okay, noted. So, Judge Heba, you can proceed. You can go ahead.
I don't have any questions.
Okay, so I think I'm done with my questions. I've taken note with your claims and your response. You can proceed with the counterclaim briefly, so we can.
The Lordship, if I may
Yeah.
just interject, I think we're supposed to have like rebuttals and rebuttals before that.
Yes, this were yeah. The order now is the rebuttal of by the claimant before we move to the counterclaim.
Okay, great.
Thank you once again for granting me audience, distinguished members of this court, Your Lordships. I remember my humble self, Chief Michael, and I'll be taking my rebuttal for the next 10 minutes. Counsel has actually listened to the reply of senior counsel to the defendant, and honestly, I do appreciate the submissions, the well-distinguished submissions of counsel on the other side. But it's important that I make some certain clarities and point out some discrepancies which will actually help this court determine these claims before it. Now, firstly, on the issue of the contractual liability of the defendants, which counsel addressed first. She addressed it on two major standpoints, which is first, that is the breach of the obligation based on the declaration form and the medical law, which was given to my client. And secondly, she also addressed it based on the fact that she believes that her client had actually done the best effort in ensuring that risk was avoided. Now, on the first standpoint, which she addressed as to the issue of violation of the declaration log and the medical, the declaration form and the medical report, it's important that I bring it to the notice of this court that the requirement for the declaration form was subjective and not objective. That is, the statement provided that my client should provide, to the best of her knowledge, any medical condition or symptom that would deprive her from participating adequately in the trip. My client, as I reiterated earlier, has consistently conducted her yoga experience for the last 5 years before this trip. And it is only reasonable that she would not disclose a mere headache she has been experiencing that has not, in fact, prevented her from continuing her yogic experiences during her YouTube videos and all of that. So it is only normal and it is only of reasonable expectation that she would not believe that it would by any means prevent her participation, her effective participation in the yogic experience. Now, it is important to place a disparity, Your Lordship, distinguished members of this court, a disparity between the headache and what was found by the PCR test. Now, this court will have to note that what actually prevented the successful completion of the trip was COVID-19 variant, not headache. Meaning that there is a likelihood that, assuming but not considering she had actually disclosed that headache, there would still be no fault found on the part of the defendant. I mean, the trip was not suspended. She was not withdrawn from the trip because the medical expert, the nurse and the doctor finally discovered chronic headache on her part. That was not what was discovered. What was discovered was COVID-19 virus. So I find it very difficult to place the two side by side and see them as a justification for the exculpation of the defendant from liability. Now, it's also important to know that just as a normal human being would go to a hospital, I mean, we all normally have a lot of symptoms when we fall sick, and we don't normally disclose all the symptoms. But that is why we go through tests. That is the main essence of tests. You don't go to a hospital and the doctor holds you by your testimony of what you feel. No, the doctor conducts tests and holds you by the results of those tests. And all those tests prove that my client was fit and proper to participate in the yogic experience until the PCR test, which brought about liability. Now, going to that PCR test, which is in question, it's important to note, Your Lordship, that assuming but not considering that the defendants had halted the flight, the launch for just an hour, Your Lordship, just an hour, that it would have been discovered that COVID variant was in my client, and whatever liability they are claiming would not have arisen at all. So this begs the question of lack of due diligence on the part of the defendant. I mean, I have stated earlier, pointing to the spaceflight agreement, paragraph 1, where the launch was supposed to hold between 15th of February to the 23rd, meaning that if 15th fails, 16th can work. If 16th fails, 17th can work. If 17th fails, 18th can work. But the defendant was such in a hurry to make ends meet, to make millions of dollars, and they could not afford to wait an hour, just an hour, to get the report of a very vital test that could risk not just my client, but the entire crew for the launch. You know, this is gross negligence on the part of the defendant. Considering how much every person paid for this trip, this is gross negligence, and the defendant should in fact be held by the neck to ensure that they in fact pay every dime of losses that not just my client, but every other person that participated in that trip has suffered. Now, moving to the other elements, the defendant has in fact conducted their best effort. Your Lordship, I would like to ask a rhetorical question. I mean, how does relying on the testimony of a nurse that it is okay to go through the flight without the recipient of the PCR test, how is that? How does that exculpate negligence? How does that exculpate medical misconduct? How does that exculpate infamous misconduct on the part of the company, the defendant, and the nurse in particular? The defendant had not conducted their best efforts in any way, because everything that had happened both to my client and to the defendant with regard to losses was a result of that haste, that unnecessary impatience on their part. Therefore, it's our submission on this ground that this court should in fact hold that the defendant is liable for breach of contract because they had in fact violated outright terms of the agreement, the specified agreement between both parties, and they had in fact negligently performed. They had not given their best efforts with regards this particular contract. Now, moving to the aspect of liability for negligence on that thought. Counsel on the other side stated that there was no form of duty of care on the part of the defendant to my client, but that's frivolous to say the least, Your Lordship. Because I mean, the duty of care as exacerbated in Donovan and Stevenson does not even need contractual proximity, does not need proxy of contract between parties to exist. It is called the neighborhood principle for a reason. And not just that, as I earlier stated, as I clearly outlined in Article 18. Article 18, not just Article 18, Article 20, Article 21 of the laws of obligation, it was clearly stated that duty of care can exist when it is reasonably foreseeable that the defendant acts would amount to loss on the part of the claimant. Now the question is it reasonably unforeseeable that someone who has paid you to conduct a trip would not suffer loss from your negligence? It means that the defendant does not understand that actually they in fact owed my client a duty of care to ensure that she was protected health-wise, economic-wise, and reputational-wise. Not just that, Your Lordship, it is important to clarify that I believe the defendant is not in fact remorseful of their negligence. They are actually just trying to place liability on whoever their hands can lay. But this is a court of justice, and I believe justice should not just be done, but be seen to be done. Yes, my client was scared about revealing her headache, her chronic headache, but it does not in any way amount or cause loss on the part of the defendant, because what was in fact discovered was a COVID virus, not chronic headaches. Not chronic headaches by any means. Therefore, Your Lordship, it is our humble submission that this court should hold that the defendant had in fact conducted its activities, its safety protocols negligently. It had conducted itself in an improper and careless manner, which has resulted not just my client's losses, damage, but had also resulted to economic, financial losses on the part of my client, and this court should in fact grant the relief asserted in our bundle, which was submitted before this current court. I rest my case on my rebuttal. Thank you.
Okay, the defendant.
Thank you very much for giving this opportunity to rebut on the opposing counsel statement. And the counsel shall begin by stating the fact that the claimant has not disclosed her medical conditions, specifically her chronic headaches, and therefore the defendant should be liable. Addressing the points made by opposing counsel regarding, firstly, the contractual obligations, that the declaration form and medical history log were subjective, the defendant provides that, as was also stated in the paragraphs 9 and 10 of the problem, during the second week of the preparations of the quarantine before the making the flight, the claimant started to suffer from severe headaches, and she didn't mention it to anyone. However, understanding that this flight requires disclosure of all kind of medical symptoms and conditions, she should have warned the defendant about it. Also, on the day of the flight, the headache of the claimant continued, although more of a dull ache. But she still were feeling a bit more tired, and she has not informed about it to the defendant. Also, considering that one of the main purposes of the claimant in participation in this retreat was curing her constant headaches and chronic headaches, we need to understand that the disclosure of such kind of symptoms was required. Secondly, addressing the point mentioned by the opposing counsel that the PCR test was delayed and those disregarded by the defendant. For that, we state that the defendant relied on the advice of the nurse on the duty that the lateral flow test was sufficient statistically to rule out any risk that passengers have COVID. And for that, the defendant also would like to provide a case which shows that the degree of accuracy of PCR is not that high, and therefore waiting for it will not have resulted in any other outcome. And therefore, mandatory flow test is considered to be sufficient for determination of the virus. The cases of the UK case of the Supreme Court of 2017, which provided that there is no need for waiting for the results of the PCR to determine whether there is a virus. Also, as pointed out by the opposing counsel, that there are other different losses suffered by the claimant due to the defendant's conduct, we again state that the defendant is not liable in any case to the claimant in terms of the tort as well, since there was no any kind of duty of care under the tort law, as well as the defendant could not have established or could not have reasonably foreseen that the claimant would incur such losses as a YouTuber due to her inability to film several series of yoga sessions. Also, the liability of the defendant does not occur because there was no intention into the breach of contract, or there was no intention that the claimant suffer such losses. And as was also stated by the defendant, the liability cannot exceed 1 million. And therefore, the claimant cannot ask for more than 1 million for the damages. And as also stated in the limitation and exclusion clause of the agreement signed between the parties, the spaceflight operators shall not be liable for any kind of loss, damage, injury, or expense, or any kind of it arising within the spaceflight, except for the liability arising from gross negligence or willful misconduct. And since none of this exists in our case, we can clearly see there is no liability, nor for the breach of contract, nor for the tort. And for that, I would like to conclude my rebuttal. Thank you very much.
Thank you. And I have a question for the claimant. You mentioned psychological damages in your written submissions. So have these been substantiated in terms of the actual psychological injury, if any?
Hello, can you hear me?
Yes, I can hear you.
Yeah, I didn't get your question. Your Lordship, if you can, please just rephrase. I guess.
In relation to the psychological damages you mentioned, have these been substantiated as to what exactly is psychological injury involved?
Definitely, your leadership. Psychological damages also arise from all I have been able to argue and say so far. Your leadership, as I earlier stated, my client is currently down by 7.5 million US dollars, down by reputational loss, which I mean, as I argued earlier, that she has over 27.3 million followers, which were in fact anticipating her videos for now for this. and all these effects. And not just that, as you all, as the court knows and quite well, counsels on the other side, my client was unduly secluded from every other participant. My client was deported, and my client suffered a lot of unforeseen events as a result of this trip. So definitely, psychological damages would, in one way or the other, come in at the end because my client has suffered all manner of losses. So I believe, Your Lordship, that this has evidently been substantiated as well. If that answers your question.
Thank you.
Yeah, thank you.
So in relation to the counterclaim, which looking at the agenda now, it should be next, but I'm conscious also of time. So do we have anyone from the DIFC court? No? So you mentioned that there is something happening now, like you have to be somewhere else? Sorry, can't hear you.
Yes, we have pleading in 230.
Okay, do you think it's enough time to proceed with your counterclaim?
Yes, we can.
Okay, please proceed then.
Okay, thank you very much. Thank you very much and good afternoon, honorable judges and respectable audience. My name is Kumar Gasimzadeh and I'm junior defendant in this case. In today's pleading, I will present the counterclaim from the defendant side, and I will start by arguing that the claimant is liable for breach of contract since she failed to disclose information about her medical condition, which is the chronic headaches of Mrs. Artemis Astoratia. And I will then continue by arguing that the claimant's action caused the reputational loss for the defendant side in an amount of $5 million. To begin with the facts of the case, I would like to emphasize that the defendant Solar Dream Inc. and the claimant Artemis Astoratia concluded a space flight agreement on 13 December 2023. And the defendant offering the space flights and travel retreats for the passengers conducted a week-long series of space mediation with yoga classes. And pursuant to this spaceflight agreement, there is a requirement for the passengers to disclose information about their medical condition. And Artemis, who is the passenger in that regard and the claimant, didn't disclose any information about the medical condition, which is about her medical chronic headaches. And Artemis had breached the agreement by failing to declare medical condition and caused significant reputational loss to Solar Dream, given the wide publicity that early cancellation of the retreat received in both Dubai and also more globally, which led to the multiple passengers canceling their tickets for the reservation for the future space retreats. If it may please the court, I would like to move my submissions. In this proceeding, defendants have two submissions as a counterclaim. First of all, claimant breached obligations under the spaceflight agreement, which is concluded on 13 December 2023, by not disclosing information about her medical conditions. And secondly, Artemis' publicly disclosure of information and wrong information about the retreat leads to reputational loss for the Solar Dream, and therefore the claimant is liable to pay the reputational loss damages to the defendant. Your Honor, firstly, we submitted that claimant is responsible for breach of contract by not informing defendant before signing the agreement, the spaceflight agreement, about her chronic headache problem. As a matter of our first argument, the claimant's non-disclosure is a violation of contractual obligation. In the agreement between the claimant and defendant, the obligations of the parties are determined. And I would like to refer to the Article 58 of the DIFC Law number 6 of 2004 of the contract law, which provides that, and it reads as follows: each party is bound to cooperate with the other party when such cooperation may reasonably be expected for the performance of parties' obligation. And I would like to take your attention to the Spaceflight Agreement, Article Clause 5.2, which declares that the passengers declares and represents that to the best of their knowledge and belief, they are not aware of any medical conditions or symptoms of a potential medical condition that may affect their fitness to participate in the spaceflight. And the duty to cooperate is considered as a principle of lex mercatoria, which is essential for smooth commercial dealings in our case. A lex mercatoria principle means that the set of rules to solve a dispute and acting as a principle in this case. And its main purpose to enable the other party to perform his obligation and thus earn the counter performance. This is based upon Article 5.1.3 of UNDRA Principles of International Commercial Contracts. The commentary of the article makes clear that the many instances in which the parties are requested and are expected to cooperate with each other in the course of contract formation and also the contract performance. And in that regard, we saw from the clause 5.2 that the passengers is required and is expected to disclose information about their health condition before signing this agreement. And I would like to refer to Article 77 of the DIFC Law number 6 of 2004 of Contract Law, where it is stated that non-performance is a failure by a party to perform any one or more of its obligation under the contract, including defective performance or late performance. And in our case, the Artemis Asteretia, which is the claimant, by not disclosing information about her medical condition, resulted in a breach of contract, which is against the clause 5.2 of the spaceflight agreement, which is concluded between the parties. And also, I would like to refer to the purpose of this article related to the medical conditions. And I would like to refer also Article 3.4.1 of United States Federal Aviation Administration Recommended Practices for Human Spaceflight Occupant Safety, which is also the integral part of the spaceflight agreement, according to the clause of the agreement, which provides that the medical consideration is one of the key factors in spaceflight operations, so that the flight crew members should not fly if they have a medical condition or psychological change that would make them unable to perform safety critical operations. And we submitted that, even though defendant take all necessary steps and includes this clause in the agreement. And besides, and the Artemis Asteretia signed this agreement, but she breached the agreement by not disclosing information. And we know from the facts of the case that the claimant, despite the claimant's commitment to a healthy lifestyle, she has experienced chronic headaches for the past 5 years, which shows that she is aware of chronic headaches. And even after consulting various doctors and exploring numerous alternative treatments, she has been unable to prevent such kind of problems. And we know it's important to know this medical condition for the defendant Solar Dream-AEC, because we know from the facts of the case that the main purpose of the claimant to participate in the spaceflight is her chronic headaches. And consequently, we concluded that the claimant breached her contractual obligations by neglecting to inform the defendant about her chronic headaches. And if your Honor doesn't have any question, I would like to move my second submission related to the reputational loss damage.
Please proceed.
Thank you. And for the second argument, I would like to refer to Article 109 of the DIFC Law number 6 of 2004 Contract Law, which stipulates that any non-performance gave rise the aggrieved party a right to damages either exclusively or in conjunction with any other remedies, except where the non-performance is excused under this law. As a specific form of damages, which is defined in Article 110 of the DIFC Law number 6 of 204, where it is said that the aggrieved party is entitled to full compensation for harm sustained as a result of non-performance. Such harm includes both any loss which is suffered and any gain of which it was deprived, and taking into account any gain to the aggrieved party resulting from its avoidance of cost and harm. And we can see that the Artemis, after the retreat, wildly and publicly announced the consequences of the retreat. And also, she includes her pre-departure headache as a result of this retreat, which is, we saw from the first argument that, firstly, Artemis breached the agreement by not disclosing information about it. And we saw from the facts of the case that the headaches, chronic headaches, is pre-departure headache, not the result of the retreat. And also, I would like to refer to one of the leading cases in DIFC 2022 dated, which is Jaima Limited versus Dubai International Financial Center Authority and Dubai International Financial Center Investment, where the court concluded that it's now accepted that the reliance loss claimed is an alternative to the expectation loss. The expectation loss has to be assessed on the basis of what would have occurred if the defendant have performed as it's alleged they should have done. And the claimant's angry description of the sequence of the event in her YouTube channel, including her pre-departure headaches, which she had aware before the flight, resulted in a significant reputational loss for the defendant, given the early cancellation of the tickets in Dubai and also globally, which led to the multiple passengers to cancel their tickets. Therefore, we submitted that the claimant's action have adversely affected the defendant's reputation and deprive it for future earnings. And therefore, the defendant should have been awarded for $5 million for the reputational loss. And by considering the time, I would like to conclude my arguments. And as a conclusion, the defendant best efforts to comply with the safety protocols and limitation and exclusion clause exempted any liability from it. And for the counterclaim, we submitted that claimant's non-disclosure of medical information resulted in a breach of contract, and also the Artemis publicly announcement and also the disclosing of information, the wrong information about the retreat, leads to the reputational loss for the defendants, which is amount of $5 million. Your Honors, we respectfully request this court to declare the claimant is liable for the breach of contract and to pay the damage of reputational loss of $5 million to the defendant side. Thank you.
Thank you. I have a question to the defendant. So you mentioned the breach on the claimant side, the allegation in relation to the breach, and reliance on the failure to disclose. Now, what I would like to understand is a bit more in relation to the causation as being failure to disclose the headache and the PCR test and result of the PCR test, which could be the case regardless of a chronic condition. So can you just elaborate on the causation in relation to the PCR and the COVID symptom situation?
Thank you, Your Honor. First of all, I would like to say the main purpose behind this medical condition clause in the space flight agreement, which is also include in the different space flight. The international space flight law, where it's said that the medical condition is one of the key factors which should be included in the space flight agreement, because if the passenger's medical condition didn't allow for them to participate in the flight agreement, they cannot. And the relation between the PCR test and also not disclosing information about chronic headaches. As a counterclaim, we said, first of all, if the Artemis disclosed information about her chronic headaches, the Solar Dream defendant did not allow her to participate in a space flight. And also, as a counterclaim, we refer to the fact that she described as her chronic headaches in a YouTube channel as a result of this retreat. And we submitted that these headaches, chronic headaches, is happened to her before the retreat and the space flight. Therefore, her wrong information in the YouTube channel resulted in a loss of reputation for the defendant side.
Thank you. That's clear. Thank you. So in relation to the claimant response now, how are we doing with time? So the question to the claimant,
Yeah.
are you?
Hello. Yeah, my co-counsel is here to address that. But initially, when we started, I informed the court that I will be taking 15 minutes for my substantive argument and 10 for rebuttals, while he will be taking 10 minutes apiece for both rebuttals and substantive argument.
Okay, please proceed.
Yeah, thank you.
Okay, good day. May it please this honorable court. I am Okike Osisiogu Barnabas Joshua, and I would like to say great congratulations to every single person who are participating in this particular competition, and a very big thank you to the judges for a very wonderful job so far. We are all happy to be here. I and every single person, every member of our team, we are really glad to be here. So back to the issue at hand. The senior counsel to the claimant had already enumerated the facts in this particular suit, and the competition has also provided a list of uncontested facts. Your Lordship, first, the counterclaim of the defendant rests solely on a claim of non-disclosure. The defendant failed or has failed to establish what the breach of contract is and how a breach of contract can amount to subsequent damages. Your Lordship, first, we'll begin by stating that the position of the claimant is that the claimant is not liable for breach of contract against the defendant. Your Lordship, why is this so? Your Lordship, Article 49 sub 1 of the DIFC laws of contract number 4 states that for there to be a contract, there must be consensus, or there must be a meeting of the minds among, according to the intent, Your Lordship, the intent of the parties. So, Your Lordship, interpretation of contracts are not just made by what is written in the words, but in the intent of the parties. Your Lordship, I would like to draw the attention of this honorable court to paragraph 4 of the uncontested fact, where the defendants in their website, where the defendant in their website explained or described this particular trip in question. In fact, Your Lordship, is not just a trip that transports passengers from Earth to the yoga mat, but it was an entire experience that was marketed. And Your Lordship, they made use of the following words: that it's going to be a once in a lifetime yogic experience to meditate amidst the stars, and participants will be able to draw upon the energies of space and enhance their life force. Your Lordship, for the past 5 years, the claimant Artemis has constantly experienced a discomfort, which is a headache that she has had to live with over and over again. Your Lordship, in seeing this particular representation, she reasoned that if she's able to align her life force, that's under paragraph 6, that if she's able to align her life force with that of space, that she's going to have an experience that will help calm this particular condition down. Your Lordship, it was at this point that a contract between the claimants and the defendant was formed. Your Lordship, this particular conversation was done orally. Your Lordship, for emphasis on date, the facts provide that this particular interaction was on 10th December 2023. Your Lordship, 2 days after this particular interaction, the claimant, the defendant, sent in a medical consent form and sent in their experts to come and examine the claimant. They requested some information. Your Lordship, I want to stress that this whole interaction was before the contract in question was signed on 13th of December. That is, I'm talking of the written contract on paper. Your Lordship, let me rephrase on this date. The oral conversation in which at exact points where my client had an understanding with the defendant and paid the full price for this particular trip was on 10th December. It was 2 days after this oral agreement that the defendant now sent in medical experts and then requested or demanded, quote and unquote, that the claimant make available to them her medical history. Then it was on 13th, a day after that, that the said contract was signed. Your Lordship, this creates a scenario where the rule of contra preferentem can apply. Reason being that the formation of this contract rests solely, in the hands of the defendant. They were the ones that drafted these clauses. They were the ones that imputed them after they had made demands. Your Lordship, I want to emphasize on that. After they had made demands for medical histories to be computed. And Your Lordship, a very beautiful effect of the rule of contra preferentem is that it goes to interpret ambiguity in a contract against the maker of the contract. Your Lordship, moving on. The provisions of the contract as it relates to medical evaluation reads, and I'll seek leave of the court to quote verbatim for the purposes of emphasis. Paragraph 5.1 states that the passenger agrees to undergo a medical evaluation conducted by a qualified medical professional designated by the spaceflight operator to determine, quote, Your Lordship, emphasis, their fitness, Your Lordship, I repeat, their fitness for space travel. The evaluation may include, Your Lordship, may, the contract making use of the words may include, but not limited to, a review of the passenger's medical history, physical examination, and additional deemed necessary by the medical professional. 5.2 goes further to stress that the passenger declares and represents, to the best of their knowledge and belief, Your Lordship, they are not aware of any medical conditions or symptoms of a potential medical condition that may affect their fitness, Your Lordship, that may affect their fitness to participate in the space flight travel. Your Lordship, I would like to draw a very close link between the headache in which my client has suffered for over 5 years and the resultant cause or the ailment claimed or alleged that disrupted the trip for my client, which is COVID. Your Lordship, my client is resident in Canada. COVID was first reported in Canada as of January 25, 2020. Your Lordship, this particular ailment has been a very known ailment, not an ailment, a very known condition my client has experienced for the past 5 years, meaning that the ailment outdates the origin of COVID in Canada, meaning there can be no link between the COVID and the said headache. Your Lordship, moving on. So Your Lordship, moving on. It is clear that the non-disclosure these people that the defendants are trying to base their claims on had nothing to do with the reasonable belief of the claimant that it will affect her fitness, because for the past 5 years the claimant has consistently participated in physical activities, has actively done yoga for the past 5 years, ran a successful YouTube page that she has built to over 20-something million followers. Your Lordship, she couldn't have done that if she wasn't participating actively in physical activities and if her fitness was in question as regards whether or not she could travel. So that was why she reasonably believed that wasn't a condition necessary to declare as one of the conditions that can affect her fitness to participate in that particular trip, Your Lordship. So moving on, Your Lordship, following the rule of contra preferentem as provided in Article 54 of the DIFC rules of laws of contract, it means and entails that article that paragraph 5 of the agreement should be interpreted against the maker of the contract because of the ambiguity of and the choice of words used, which fails to provide clarity as to what is meant by reasonable belief, as what is meant by may affect. May, your lordship, may doesn't really state specifically whether or not it's going to affect an illness or not, your lordship. So that particular interpretation should be resolved in favor of the claimant. To interpret it to mean that only conditions in which the claimant believes herself can affect her fitness to participate in that particular trip should be the only conditions that she is mandated or she has a duty to disclose. And your lordship, all the facts, the uncontested facts of this particular Moot competition, provided that every other thing was declared. The only thing that wasn't declared was the headache. And the headache was not declared simply because the claimant reasonably believed that it won't affect her fitness to participate in this particular travel. Now, your lordship, okay, yeah, simply because she believed that it won't affect her fitness to participate in that particular travel. So, your lordship, it is very clear from the facts of this particular case that the defendants are trying to run around their own lapses and their own failures and looking for who to impute blames on. Your lordship, the claimant did all she was required to do based following the oral agreement in which they had. The oral agreement rests solely on a promise of an experience and a desire for that particular experience, for which the claimant paid her 10 million. They paid the first installment of 2.5 of the 10 million as requested in this particular, as supposed as of 10th December 2023. The contract signed in which these people are trying to base their claims in breach of contract was done 3 days later. We are not saying the contract is invalid. It is valid. We signed that particular contract. But all we are saying is the interpretation of the ambiguity of that particular contract should be resolved against the maker of the contract and should not be used as a basis or as a form to come and impute liability on the claimant. Your lordship, moving on. The defendants try to lead arguments as regards costs for damages, as regards their plea for damages arising out of breach of contract, and they quoted very, very wonderfully so many provisions of the law. But your lordship, for damages to be paid, it must be one that arises out of that particular contract, either in specific damages or in general damages. Your lordship, they have failed to lead evidences to show specific damages as regards the 5 million naira they are pleading. How did the alleged actions of my client amount to their loss of $5 million? Your lordship, they failed to plead that. Your lordship, they also failed to plead general damages in this particular suit. So they failed to impute or follow the appropriate measure to make demands for damages in this particular suit. So that means there can't be any claim or any award of damages for them in favor in this particular suit in question. Your lordship, okay, so can you hear me?
Yes.
Okay, sorry. I think I kind of got caught at some point. You get. So, your lordship, moving on. The basis of every contract is usually done on fair dealings. The actions of my clients in this particular suit has been to follow stricto sensu the provisions of the contract, providing information as were required that she reasonably believes were necessary or that may affect her fitness to travel in this particular trip. And your lordship, the chronic headache which the defendants are trying to rely on had nothing, it had no links between a condition that can affect the fitness of my clients to participate in this particular trip. Your lordship, when they were leading their claims, they also stressed that the claimant failed to disclose the change in her medical conditions. Your lordship, I would like to direct the attention of this court to paragraph 10 of the uncontested facts, where it was stated that the headache continued, but now order of a dull headache. Your Lordship, a condition someone has lived with for the past 5 years, a condition someone has lived for the past 5 years, and it has not affected any of our trip. Of course, it has its peak and its flows. So that the fact that it was now even low shows that at that particular point, that my client was, of course, fit enough, and the headache was not even going to be a problem at all to participate in that particular trip. So, Your Lordship, it will be unfounded to grant these people's claims for breach of contract against the claimant. Moving on, to grant these people's claims for breach of contract against the claimant. Your Lordship, moving on, the medical evaluation carried out was done by experts employed by the defendant themselves. Your Lordship, these experts examine the fitness of the claimant in their own expert opinion. Your Lordship, in their own expert opinion, they deemed the claimant fit, proper to travel and participate in this particular trip. It is funny or quite laughable that the defendant can now run back to now say that this particular person was not fit to participate in this trip ab initio, and her failure to tell us that she was not capable to participate in this trip amounted to us making losses. Your Lordship, are they now trying to deny the qualifications of their experts? Your Lordship, it now tends to show that they are trying to plead the negative. They are trying to shoot themselves on the leg. Are they trying to tell us that they employed people who are not qualified to determine fitness of persons? Your Lordship, I would also like to bring to the attention of this honorable court that headaches are not diagnosable diseases which are to be noted by which ordinarily like somebody cannot go to hospital and be declared positive for having headaches. Your Lordship, headaches are symptoms of broader ailments. Your Lordship, it could be ailments like, for example, Ebola. It could be ailments like malaria and others. So headaches are usually symptoms. Your Lordship, my clients who visited hospitals during this period that she has experienced this headache went to check whether these headaches are linked to any ailment, and of which the expert opinions show that she was not sick in any way whatsoever. So, Your Lordship, that's to tell you that there was no medical history in question to report, because all the doctors visited didn't declare any ailment that needs to be reported. All the doctors visited declared her fit and okay. The only thing was she kept experiencing discomfort. Your Lordship, it would be unfair and it would be unfounded to now rely on that particular headache to grant the claims of the defendants for breach of contract, when there was in fact no breach of the terms provided in paragraph 5 of the agreement. Your Lordship, may it please this honorable court.
I have a question to the counsel, please. So the submission made by the defendant that the claimant made no mention of the chronic headache because she was afraid that Solid Dream would not allow her to participate in the retreat. How does the claimant respond to that? Is this a submission disputed or agreed as to the reason why it was not disclosed?
So, Your Lordship, the reason why it was not disclosed specifically was because it was not a condition that the claimant reasonably believed will affect her fitness to travel. Your Lordship, I would like to be given a moment. Let me kind of retrieve the Moot facts in that particular paragraph where it was mentioned that she didn't disclose it because she was afraid that she will not be allowed to participate in the travel. Your Lordship, while doing that, I also like to remind this honorable court that the defendants failed to show that headaches were one of the conditions in which they themselves consider as a reason not to allow somebody participate in a travel. So, Your Lordship, the question of what my client was thinking or what she had in her mind, it didn't in any way affect the contract entered into between my client and the defendant. Your Lordship, it will be also necessary to remind this honorable court that silence does not amount to misrepresentation. So, Your Lordship, my client not having a duty to disclose that particular fact, her reason for deciding not to disclose it not being relevant to the agreement, her silence to it cannot amount to her misrepresenting facts to the defendant. And even if and cannot amount to her misrepresenting facts to the defendant, and the defendant had not even claimed misrepresentation which induced them to enter the contract, Your Lordship, the action before this court is a claim for breach of contract. So they are saying even the non-disclosure, whether it was disclosed or not, did not affect them. So their only problem in this particular instance was that there was a breach, and not that it wasn't that it was a condition that she was supposed to disclose, and if she had disclosed, they wouldn't have entered the contract. Your Lordship, they didn't plead that. So, but for the sake of clarity, let me get the particular paragraph. Let me get the particular paragraph. Just a moment.
I think it's paragraph 8, if I'm not mistaken.
Okay, yeah, paragraph 8. So, Your Lordship, okay. So on first, okay, sorry, that was not it. 2 days after she purchased the ticket, Artemis was contacted by employees of Solar Dream and was told that she had to carry out a medical evaluation before she could fly. She was provided a declaration form from which she provided that, to the best of her knowledge and belief, she was not aware of any medical condition.
2 lines in paragraph 8.
Okay. Okay, Artemis made no mention of her chronic headaches because she was afraid that Solar Dream would not allow her participate in the retreat. So, Your Lordship, as we have already submitted, the provisions of the contract, what the two parties, at the point where the two parties had a consensus added them, had nothing to do with that particular condition in which she didn't permit, she didn't disclose. So there was no duty to disclose that particular fact. And since there was an absence of a duty to disclose it, it cannot be used as a basis for a breach of contract. Your Lordship, the fact that my client probably wakes up every morning and does skipping is not necessary or a fact to actually disclose to enter into a particular contract with the defendant. And that particular fact that she wakes up every morning to do her skipping was not equally disclosed as an example, Your Lordship. So that's to say that irrespective of her reasoning to withhold that particular information, the duty is on the defendants who drafted the contracts themselves to state expressly the conditions in which, if it was found, they wouldn't permit the claimant to participate in their trip. And if they had done that and headaches were provided and the claimant then failed to make declarations of that, then the claimant can be found wanting for a breach of that particular term. But then it was not a provision in the term of the agreement, either orally, either when the first medical, when they send their first medical experts for evaluation, nor when they even send the document to come and sign. They never made it expressly clear that once you have headaches, we will not permit you to participate in this particular trip. May you please, Honorable Court.
Yeah, thank you. The defendant, you have the floor.
Yes, can you hear me well?
Yes.
Great. Thank you very much, Your Honor, for the opportunity to rebut the opposing counsel's statement. And the claimant referred to the fact that defendant is failed to show the relationship between the damage and the breach of contract by the claimant. And also, claimants refer some interpretation of the clauses of the spaceflight agreement. Firstly, we would like to begin that the defendant, the claimant, refers to the fact that the 2 days after Artemis purchased the ticket for the space flight, she was informed and contacted by the employees of the Solar Dream and was told about that she had to carry out a medical evaluation, even though we saw from the paragraph 7, the page 5 of the case file, that the Artemis read and signed a copy of spaceflight agreement, which we refer to the clause 5 of the spaceflight agreement. And in that clause, it's explicitly written that the parties should disclose information about the medical condition which can affect the spaceflight. And even though 2 days after she was contacted, she was already aware about this clause in the spaceflight agreement when she's signing this agreement. And then the claimant referred to the interpretation of the Article 5.2 and the Clause 5 of the Spaceflight Agreement, but it is explicitly written in the 5.2 that the passengers declares and represent that to the best of their knowledge and belief, they are not aware of any medical conditions or symptoms of a potential medical condition that may affect their fitness to participate in this flight. And in that regard, also, claimant said that she didn't disclose the chronic headaches because the Artemis considered this headache as a simple disease. And usually people normally, when they go to the hospital, they don't say about the chronic headaches. But we saw from the paragraph 8 and page 5 of the case bundle that, and we saw that the claimant falsified the facts. And Artemis was not disclose information about her medical condition, about her chronic headaches, because she was afraid of that it can affect her participation in the space flight. And also, I would like to say that we saw from the case file that the main purpose and the main target for participating in the space flight for the Miss Artemis is that she suffered from chronic headaches, and she considered that being in a low gravity can heal her headaches. That's why we saw that she also aware the importance and necessity of the disease, and also she should inform about her chronic headaches to the defendant. And the defendant also, the claimant also refers to the fact that defendant should name all the disease in the agreement which can affect the space flight, but it's not reasonable and it's not standard to write all the disease that can affect the space flight, because it varies. It depends on the people, it depends on the immunity of the people, and it's not reasonable for expecting from the defendant to define all the name of disease in the space flight agreement. And the relationship between their reputational laws and the act of Mrs. Artemis is that Mrs. Artemis, in her YouTube channel, angrily described the consequences of the retreats, including her pre-departure headaches. And we submitted that the headaches, chronic headaches, was before the travel retreat. And the description of these chronic headaches as a result, as a consequence of this travel, also resulted in many passengers cancel their tickets for the future retreats. And therefore we submitted that and we request the court to consider the claimant is in a breach of contract, and also the claimant is liable for the damages of reputational loss for 5 million. Thank you.
Thank you. Sir Rebuttal by the claimant, please.
Okay, thank you very much, Your Lordship. I don't know, am I clear enough?
Crystal clear, thank you.
Okay, Your Lordship. Your Lordship, the defendant failed to note a very important fact in the uncontested statement of facts. Your Lordship, the day in which my client made payment, paid her first installment for this particular trip, I repeat, was 10th of December. Your Lordship, it was 2 days after 10th, which is 12th of December, as provided by the uncontested facts. By the uncontested facts, paragraph 8. Okay. Yes, by paragraph 8, that they requested those information. So, Your Lordship, even the declaration in question was even outside the contract in which the claimant had relied their claims on. So, Your Lordship, it's funny, or it is quite wrong or absurd technically that they failed to note the date in which this particular contract was signed. The contract wasn't signed on 10th December. It was signed on 13th December. Your Lordship, I would like to lead counsel to the defendant to make reference to the foot of the contract in question in which they brought their claim. The date there expressly states, date of signature between both Artemis and that of Solar Dream, we are 13th December. Your Lordship, their medical evaluation was done on 12th December, which was the day before. So, Your Lordship, even the agreement in question is, the contract in question is even different from what's it called, the basis of their breach of contract? Can something that happened something that happened in retrospect before the contract was entered be used or become an effect of a contract that was signed? Your Lordship, no. Your Lordship, the agreement between my client and the defendants rests solely on their promise of an experience, followed by my client's interest in that particular experience. Your Lordship, I enjoyed it when she tried to explain that my client had an experience in which she feels that the energies of Earth doesn't really align well with her system, that this particular experience would have given her that liberty to align herself with the energies of the celestial bodies. Your Lordship, this was the promise that the defendants made. Your Lordship, this was the promise that the defendants failed to keep to. Your Lordship, it was based on this promise that my client, after speaking with their representative on 10 December, paid, which was the first arm of the contract, that particular payment. At that particular point, there was no duty to disclose, there was no requirement for medical evaluation. It was 2 days after that payment has been done that there were requirements, that there were requests that for her to disclose conditions that she feels or she believes can affect her fitness to travel. 2 days after, Your Lordship. So it means that by 2 days after she had obliged to actually make declarations, it was at that point that there was a second contract, which is the agreement for me to declare conditions I believe will affect my fitness to travel, and of which, Your Lordship, we had already led arguments that the headache was not part of them. Your Lordship, now the third arm of the contract was not the one that the defendants themselves reduced into writing. And that particular one, the reason is marred with a lot of ambiguities, which is why we have directed the attention of this honorable court to the provision, to the doctrine of contra preferentem, which means any ambiguity interpreted in a contract where a party has the larger advantage when it comes to drafting or making the contract, that the contract will be interpreted against the maker of the contract. And to this, we have led argument to show that even the interpretation of paragraph 5 of the agreement will still not favor that the claims in contract of the defendants. So it means they still have no claim under paragraph 5, because when you interpret the provisions of that paragraph, the entire provisions, it rests solely on belief and on fitness to travel. Your Lordship, the defendants never said or made any statement as regards whether or not a headache affects the fitness of my own client, which is a subjective test to her, whether it can affect her own fitness to participate in the trip. Your Lordship, that wasn't the case. It was shown by the uncontested facts in this suit that the Artemis, that's the claimant, had consistently participated in her physical exercise, had consistently participated in a lot of her yoga sections and a lot of other physical exercise without any issue. The only thing is she has always felt uncomfort with a frequent headache that she has always experienced, which is not a known diagnosed medical condition. Your Lordship, moving on, so which is not a known medical condition. So, Your Lordship, when they try to make amends to what was already spoiled, they try to lead links between the actions of my client to their lawsuit. Your Lordship, they still failed to explain how the cancellation of trips amounted to a loss of $5 million. They still failed to lead that particular evidence to pinpoint it as per saying this is the damages arising from the breach. And here, Your Lordship, I'll conclude with this statement. Which of the breaches are we speaking of specifically? If it's the breach of Article 5, in which they've relied their claim mostly on, which was the third contract in question, Your Lordship, the provisions of that contract, it is very clear, and it has been explained to this honorable court that the claimant was not in breach of them. She declared all necessary facts as it relates to conditions that can affect her fitness to travel, Your Lordship, her fitness to travel. So, Your Lordship, the is a known provision in contract law that terms of contract should be interpreted in line of the intent of the parties. In line of the intent of the party. And in this particular scenario, in this particular situation, it has been shown that this particular contract was run up solely by the defendant. So meaning the rule of contract preferentem will work to go against them for any ambiguity contained in the contract. And the contract in question was not drawn in a way to leave off any form of ambiguity. It uses terms like may, not shall.
Counsel, I have a question, a clarification on the submission made by the defendant as to describing in public that the headache was a result of the trip. How do you respond to that?
So yeah, Your Lordship, which was in fact in response to that, it's simply the reason why we have stressed the intent of the parties, which is where the defendants had explained or described this particular experience in which they attempted to sell to, in which they sold to the claimant. They had explained it to be, and because I like the emphasis of quoting as it is, as it states, once in a lifetime you give an experience amidst the stars to draw upon the energy. Your Lordship, am I still clear on
You're breaking up a bit, but generally, can you speak, please? I can't hear anything.
Having network issues. Just bear with me patient. We'll be back. I think. So sorry about that.
Hello?
Yes, we can hear you.
Okay, I think we lost.
Yeah, Your Lordship, can you hear me?
Yes.
Yeah. So he's having a little bit of network problems. He would join us shortly. He could just exercise a little few minutes and he'll join us.
Okay.
Sorry about it, please. Thank you. I think he has joined us.
Your Lordship? Am I on the corner? Hello? Am I clear?
Yes. Yes, absolutely
Yeah,
clear.
okay.
Thank you.
I sincerely apologize. My device went off, so I had to look for another power source and plug it back. So, Your Lordship, as I was explaining, the promise of an experience where participants or passengers can draw the life energies of space to enhance, can draw from the energies of space to enhance their life force, informed the decision of my clients to participate in this particular trip. And it is at that point that there was a consensus at them, because she believed she needed the life force to see. She needed the energies of space to enhance her life force, to see if it would calm the uncomfort of a frequent headache she has always experienced. Your Lordship, um, summarily, the claims of the defendants in breach of contract read solely on the headache being a medical condition that was not disclosed. Your Lordship, conclusively, the headache was never a medical condition that my client was diagnosed with, because it was stated in the fact that she has visited so many doctors. And as it is with so many other ailments, when you declare a symptom, it is checked whether you have that particular ailment and if that ailment is treated. And those doctors visited never linked the headache to any ailment. So it means it was not a medical history that even necessitates what was it called? Disclosure ab initio. Now, assuming that even necessitates disclosure, and now moving on, the only medical conditions that they were even asked to disclose, that's assuming but not conceding that the medical condition, that the headache was a medical condition. The only medical conditions that they were even asked to disclose are those that can affect their fitness to participate in the trip, and of which, Your Lordship, we had conclusively shown, and as I stated during my oral arguments, it did not, the headache was not a condition that has affected her fitness to participate in anything whatsoever. She has done her yoga for 5 years consistently with no issue. Your Lordship. So now,
Yes, we were able to hear you perfectly. Is everything okay?
Your Lordship, I think he's having a lot of issues with his device, but I believe he has concluded his sorry rebuttal. Can you hear me?
Yes, we can.
Okay.
Okay, I'll step out of character for a second, just to let you know, I mean, taking into consideration all the technical issues we've been facing and the login and the delay and the time squeeze for both parties, all of this will be, marked in favor of the parties. So don't worry if you had to squeeze yourself or to deal with technical issues, not be to be penalized in any way in the scores.
Your Lordship, I apologize for the frequent back and forth.
Don't worry.
The
You know,
thing is,
I
we've
suggest
been up.
I suggest you, if you close your video, maybe if it's a network bandwidth issue, maybe if you close the
Okay.
video, it would be smoother from network perspective.
Okay, no problem. I was already rounding up my argument. So, Your Lordship, as we've shown, just to rephrase, for there to be a breach, there must be a contract. We have shown that this agreement was in 3 different stratas, and in those 3 different stratas, there were different terms and conditions, and one that happened later cannot be allowed to apply retrospectively. That's as regards the medical evaluation that was done a day before the agreement was even signed. So it means the defendant's claiming for breach of contract is kind of defective because it relies on the provisions of the contract, but the facts in which he's trying to place his claim on happened before the contract was signed. So conclusively, Your Lordship, we pray this honorable court to
Just to clarify a question to the defendant counsel, the purchase of the ticket and the signature of the agreement was on the 10th of December. The declaration form for the medical status and the medical condition was 2 days after.
Thank you very much, Your Honor, for your question. I would like to submit that, yes, firstly, Mrs. Artemis read and signed a copy of spaceflight agreement, and 2 days after the form related to the medical condition were sent to her.
good evening, Your Lordship.
Yes, please. Can you hear us now?
Yeah, I can hear you, but I see the leave of the court to make use of this other device.
Okay, so I just had a question in relation to the 2 days difference that you referred to. This, so the medical declaration was 2 days after the contract, right? Not before.
Yes.
Or did I?
Your Lordship, it was 2 days after purchased the ticket, the paragraph 8 of the uncontested facts. So it was 2 days after the purchase of the ticket. So that was 12th December 2023.
Okay, so
And the contract was signed on 13th.
So the declaration was after the contract. So what's the point that the claimant is trying to make here in relation to the difference in time?
Okay. So, okay, in regards to the difference in time, Your Lordship, we are saying that they are relying their claims on breach, first on the term of the contract that was signed on 13th, but the facts in which that surrounds that particular term of the contract happened a day before the particular contract was signed. So, Your Lordship, it means that there is a discrepancy between the facts they are trying to rely on in pursuit of that particular claim and the document in question in which they rely. And the documents cannot apply in retrospect.
Can you specify the fact that happened 1 day before, just so everyone knows which?
Okay, the fact that happened 1 day before was 1 day before that she was contacted to make declarations as regards her medical history. And that 1 day before, because based on she was just called to, there was no punishment or any provisions of any contract that mandated her to make those particular declarations. Those provisions came a day after she has already done her declaration. So it means even if that what our argument there is assuming but not even conceding that the ailment in question is ruled as is ruled to be a condition that she was supposed to declare. The duty to disclose only arose a day after the said declaration, which was when that particular contract was signed.
Okay, thank you. So the claimant position is that I can hear myself. Sorry, there's a feedback. Can you put yourself on mute?
Okay.
So it's your position, it's the claimant's position that I can still hear myself.
Okay. Yeah, Your Lordship, you are quite clear, sir.
Okay, just put
Sorry,
yourself
your
on
lady.
mute.
Sir?
Just put
Sorry,
yourself on mute.
your ladyship. Okay, I should mute myself. Okay.
Yes, please. Yeah, thank you. So my question is that in relation to your submission is that the claimant was contacted to do the medical evaluation before, but the defendant submission is that it was 2 days after the contract where she was contacted.
Yes, Your Lordship. She was contacted to make the declaration before the contract, and I raised this specifically. Your Lordship, you can take a perusal of the contract in question contained in the Moot problem, where the contract was signed 13th December. The ticket was paid for 10th December, reference to paragraph 7 of the Moot problem, and it was 2 days after the purchase of the ticket, which was 12th December, that the claimant was asked to make those declarations, and which is before that particular contract was made and signed on the 13th. So may it please your ladyship.
Okay, thank you very much. Is that conclusion of your submission?
Our submission is to discountenance the defendant's counterclaim for breach of contract because it's unfounded on any grounds whatsoever. And we also pray this honorable court to grant our reliefs contained in our court bundle, and specifically granting the amount of 7.5 million being refunded for the unfulfilled part of the contract by the defendants, and another 7.5 million in special and general damages as already pleaded, which amounts to 15 million as already pleaded by my senior counsel. May it please honorable court.
Thank you. So this is the last part of today's hearing. Thank you, everyone.
Thank you, Your Ladyship.
Thank you very much.
Okay, step out of character and have a lovely day. Thank you, everyone.
Thank you. Have a nice day.
All right, thank you. Have a nice day.
Thank you, guys.